Hi there. Today I'm going to be talking about the timeline in a divorce case when filing for divorce in Colorado. So first things first, you're going to have to file your petition with the court. When you file that petition, you will also have to serve the other party with those documents. Now, you cannot serve the other party yourself. You will either have to hire a process server to do it for you, or the other party can waive service. Either method works. Once the other party is served, the clocks then begin for those specific deadlines throughout your divorce case. Now, before I get into more detail about those specific deadlines and those major events in a divorce, I'd like to strongly recommend that you first check the case management order of the specific judge that is handling your case for further details pertaining to those deadlines, as these deadlines are very judge-specific, and they're listed in the case management orders, or CMO. But here's a general outline of these deadlines in a divorce case so that you have a better sense of what to expect if you ever decide to file for divorce. So after you file your petition and have the other party served, you will have to attend an initial status conference. In that conference, the court facilitator will provide deadlines for financial disclosures, deadlines to schedule mediation, deadlines to file notices to set final orders, the final orders hearings, and the court facilitator will also ask you if you need a temporary orders hearing. Now, in regards to financial disclosures, generally the courts provide 42 days from the date of service for the parties to exchange those disclosures and to file their sworn financial statements. Now, the financial disclosures are basically the assets and the debts of each party, and the sworn financial statements are basically a summary of those disclosures. If you have any pressing issues that you'd like to address, such as temporary parenting time or temporary support, you can certainly request a temporary orders hearing with the court. Now, as long as one of the parties makes this request for this hearing, the other party must attend. If the parties reach an agreement prior to the hearing, you can file your stipulation with the court, and you must let the court know that the parties have come to an agreement so that the court can vacate the temporary orders hearing date. Now, I recommend that you schedule this hearing sooner rather than later. A good rule of thumb is to schedule this hearing no later than 60 days from the date of service. The date for this hearing is usually set out about 3 to 4 weeks out. However, this is primarily reliant on the judge's availability and the judge's schedule. So the date for your hearing could be set out much further than that. Now, currently, due to the pandemic, these hearings are set out about 2 months or so from the date of your request. So again, a good rule of thumb is to schedule this hearing sooner rather than later. The next step is a required step, which is mediation. Usually, courts provide 91 days to schedule a mediation in order for the parties to resolve issues in their divorce case. And again, this is a mandatory requirement if there are any unresolved issues or pending issues left in your case. The judge will not hear your matter in a final orders hearing if you did not attend mediation. So mediation is very important to attend, very important to schedule that. And again, courts give 91 days to schedule a mediation. Now, throughout your case, if you're looking at financial disclosures and you need to take a deeper dive into the other party's finances, or if you have to ask them specific questions, for example, about parenting time, you are able to do that through formal discovery. And generally, courts require that this step be completed no later than 35 days before the final orders hearing. The last step is the final orders hearing. Now, this hearing must be scheduled prior to the court's 120-day review of the case. Now, the date of the final orders hearing weighs very heavily on the judge's schedule and availability. Currently, due to the pandemic, these hearings are being scheduled about 4 to 6 months out, sometimes much further than that. However, if the parties do come to an agreement and mediation is not needed because the parties have agreed on all issues, then the parties can file their separation agreement and other related documents with the court. Now, there is a little bit of a catch. Just because the parties have agreed on all pending issues doesn't necessarily mean that the court is going to adopt their separation agreement and other documents as orders of the court right away. So there's something called a cooling off period or a waiting period. And so parties have to wait at least 91 days before the court can accept their separation agreement and adopt their separation agreement as an order of the court. So, in summary, as a best case scenario, if you want to file for divorce and the other party also is on board with the divorce and everyone has come to agreements on all pending issues, you can go ahead and file all of your documentation with the court. However, you're going to have to wait 91 days before the court can accept your documents and adopt them as orders of the court. I hope this presentation was helpful. For more information, legal assistance, or videos like this, please visit the Justice Center at justicecentercos.org.